So, imagine this. You've been injured, and you just know someone was careless, but you have absolutely no way to prove it. Well, in law, there's a really powerful tool for situations just like this, and it has this fascinating Latin name, res ipsa loquitur. Today, we're going to dive into what that means and exactly how it works.
Let's start with a classic scenario. You're walking down the street, minding your own business, when, bam, a barrel of flour falls out of a warehouse window and hits you. You are knocked out, no witnesses, nothing. You know someone messed up, but how in the world are you supposed to prove that in court? This isn't just some random hypothetical, it's the actual problem that gave birth to the entire doctrine we're exploring today.
And here's the legal mountain you'd normally have to climb. The law says the plaintiff, that's you, the person who got hurt, has the burden of proof. You have to prove every single element of negligence, that there was a duty, that the duty was breached, and so on. Without direct evidence, like an eyewitness pointing a finger, your case would typically just get tossed out. It seems like a total dead end, right?
But to get around this impossible situation, the law has a pretty cool trick up its sleeve. It's a special kind of evidence all wrapped up in a very famous Latin phrase.
Res ipsa loquitur. It literally means the thing speaks for itself. And the whole idea is that some accidents are just so obviously the result of carelessness that the accident itself becomes the proof. It basically allows a jury to connect the dots and infer that, yeah, the defendant was probably at fault, even without a smoking gun.
And this is where it all started. Back in that actual 1863 case with the falling flour barrel, Byrne versus Bodle, a judge named Baron Pollock just cut right to the chase. His point was pure, simple common sense. Barrels don't just magically roll out of windows. The event itself tells you pretty much everything you need to know. And with that one observation, he nailed the entire principle.
So how do you actually get to use this powerful tool? Well, it's not a free-for-all. To successfully argue res ipsa loquitur, a plaintiff has to pass a very specific three-part test. Let's break down these rules of the game.
These are the three pillars of res ipsa. Think of them like a three-item checklist you have to complete to get your case to a jury. First, the accident has to just scream negligence. Second, you have to prove the defendant was the one in control. And third, you can't have contributed to your own injury. These are the three rules to lock into your memory.
Okay, rule number one is all about probability. Just think about it. Elevators don't just drop out of the sky, surgical tools don't usually get left inside patients, and, barrels don't fall out of windows in the normal course of business. The accident has to be the kind of thing that makes any reasonable person go, yeah, someone probably messed up here.
Next up, step 2. This one is all about connecting the negligence to a specific defendant. You, the plaintiff, have to show that the instrumentality of the harm, the barrel, the elevator, the surgical tool, was under the defendant's exclusive control. This is how you point the finger and say, you were in charge of this thing, and this thing is what hurt me.
Now, this third rule is where things get really interesting because it has changed a lot over the years. Originally, the plaintiff had to be totally 100% blameless, but modern law is way more flexible. We have this idea called comparative negligence, which basically allows fault to be shared. And that's a huge deal. It means that even if you are maybe a little bit responsible, it might reduce your payout, but it won't automatically kill your chance of using res ipsa loquitur.
Okay, so we've got the rules down. Now let's see how they actually perform in the wild. Looking at real court cases shows you just how tricky applying this three-part test can actually be.
Check this out. The Cosgrove case is a perfect example of that first rule, the probability of negligence in action. The court looked at two different utility failures after a storm. For the down power line, they said, nope, res ipsa doesn't apply. Why? Because storms, lightning, even a squirrel can knock down a power line without the company being negligent. But for the ruptured gas line, they said, yes, the doctrine applies. The reasoning was that buried gas lines are protected. They don't just break on their own unless someone was probably negligent in maintaining them.
And that exclusive control rule? Oh, it gets super tricky when more than one person is involved. Look at these two cases side by side. In Novak, a furnace was damaged, but it had passed through the hands of the manufacturer and a shipping company. The court said res ipsa fails because the plaintiff couldn't prove who was in control when it broke. But in Collins, a vulnerable patient was injured while being tasked from an ambulance to a care facility. Here the court did apply the doctrine. They basically said when you have consecutive control over a helpless person, the burden shifts to the defendants to sort it out and explain what happened.
All right, let's pull all that together and really cement what we've learned. In Cook's, context was everything. A power line falling in normal wind does imply negligence, unlike the major storm in Cosgrove. The big takeaway from Giles is that responsibility for maintenance is what really matters. And as we just saw, Collins and Novak give us this fascinating contrast on how courts deal with multiple defendants. It's so clear from all this that the specific facts of every single case are absolutely crucial.
So, why do we even have this rule? What's the point? Well, it's not just about helping plaintiffs win. It actually serves a much deeper purpose in the whole system of justice.
At its heart, res ipsa does a few really critical things. First, and most obviously, it stops a legitimate case from getting thrown out just because of a lack of direct proof. But maybe more importantly, it has what lawyers call a smoking out function. Think about it. The defendant is usually the one who actually knows what happened. This doctrine basically forces them to come to the table with evidence and explain themselves. It helps level a playing field that can be really tilted.
But, and this is a big but, this leads to a really interesting modern debate. See, in today's legal world, we have these extensive discovery rules that let lawyers demand documents, emails, and all sorts of information before a trial even starts. So some people are now arguing that maybe we don't really need the smoking out function of res ipsa anymore, because plaintiffs already have other powerful tools to find out what happened.
And that leaves us with a great final question to chew on. Is this doctrine, born from a falling flour barrel over 150 years ago, still essential today? Or have all of our modern legal tools made it a bit of a relic? In an age where we can do these massive, deep-dive investigations, does the thing itself still really need to do the talking? Something to think about.